And hello there and welcome once again, Employment Law Show. John Scholes, Lior Samfiru. We are side by side, but we're keeping our distance. We have a very active and busy show today. Temporary layoffs, what you need to know during COVID-19. Couldn't possibly be more topical. We will tackle that and some phone calls from our live employment law radio show as well. Reaching out anytime, you know the number, 1-855-821-5900, help@employmentlawyer.ca. All that is coming up, Lior, my brother, but the week that was, what's going on your side?
Well, John, glad to be back here. Glad to have this opportunity to talk about employment law and hopefully solve some problems, help individuals with their issues, workplace issues. The past number of months with COVID-19 has been crazy and difficult in so many ways and so many aspects, but it's impacted people's jobs, job security, compensation, and their rights. So it's important that you know what to do if you're in a difficult work situation, if you lost your job, if you've been put on a temporary layoff, if your job has changed, if you're not getting answers from your employer. That's what we're here to do, to talk about those things and hopefully educate you about what you need to know. So stay tuned. We'll talk about a lot of important things. We'll also give you my contact information throughout the show so that you can reach out to me directly and we can have a discussion about your matter. So don't hesitate to take advantage of that. But I always like to start off the show with a situation that came across my desk where I think some of our viewers may have something to learn from it. So a big issue that I've been dealing with over the past number of days has to do with returning back to school, with children going back to school, and parents calling me saying, well, what happens if my child is not in school full time? I have to stay home with them. Can my employer punish me for that? Do I have a right to work from home? How does that work? I've been getting that question so often, so I wanted to talk about that right now. So here's how this works. If your child cannot be in school full-time, maybe the school doesn't offer right now full-time learning, they're home every other day or what have you, then your employer has to accommodate you if you need to be home with your child. If you have childcare responsibilities because your child is not at home at school every day, your employer has to accommodate you. That means allowing you time off, if possible, to allow you to work from home. Your employer can't punish you, can't threaten you, can't do any of that. That's very important to understand. If your employer tries to do something or doesn't cooperate, doesn't accommodate, that would be a human rights violation. That's illegal. But here's the difference. A lot of parents are choosing this time to keep their kids at school, to have their children engage in remote learning. That's one of the rights you have, and provinces across the country are allowing parents to do that. But here's the difference with that. If you choose to keep your child at home, but you could be sending them to school, then in that situation, the employer may not have to accommodate. And that's because it's a choice that you've made. So the concern is a lot of parents may choose to keep their children at home, not knowing that their employer can still insist that the parent go back to work. So if you have a child that you're keeping at home by your choice, talk to your employer. Tell them that's what you're doing. Try to work out an arrangement that works for you and your employer that allows you to stay home with your child as needed. I think most employers are going to be quite reasonable and accommodating. That said, if your employer says, sorry, if you're choosing to keep your child at home, that's your issue. I need you in the office every day. That could be a problem. So you have to keep that in mind. Your employer does have to accommodate if you have no choice in the matter. If there is a choice, that accommodation may not be available. If you want to discuss this, if you want to understand better your rights as a parent, as an employee, give me a call.
We've talked about accommodation when it comes to medical purposes, and you just need a doctor's note or something in writing backing from your medical team. Is this the same way? Do you need something in writing to give to the school board, or rather to your employer from the school board? Or is this a verbal thing, like, no, they're not going to school and I have to stay with them?
I think this type of issue should not be very controversial because, depending on your area, it's going to be known whether schools are full-time or part-time. If your employer doesn't necessarily believe you that your child has to be home every other day, yes, you can get something from the school to show them. I don't think most employers are going to insist, but if they do, that should not be a difficult thing for the parent to provide to the employer.
Again, the website anytime for you, employmentlawyer.ca. While you're there, you can catch past TV shows that we've done, listen to the live radio show as well. There's links to a variety of stations across the country. And we like to get some of the, cherry pick some of the phone calls we get on the radio show, play them back here, and we talk about them. First call for today's show is coming up right now.
I was recruited from a company, I had a stable job with highly specialized engineering knowledge. I could tell from day one that my hiring boss didn't actually like me. Now, I've been there for a couple of years, and some of the stuff he said has been a little bit aggressive. I'm just wondering, with my age and the time, if he was to do something, would I have some sort of decent severance?
So there's a number of things to unpack here. First of all, the fact that he's being mistreated by his boss, harassed by his boss. So remember, you have a right, anyone has a right to work in a harassment-free work environment. You don't have to take it. And if you are harassed, one of the things you may be able to do is treat your employment as being terminated. You've breached the agreement, employer, you mistreated me, so I can treat this as a termination and leave and get my severance. So right away, this person that called us doesn't even have to wait to be laid off. He can require the company potentially to pay him severance. But beyond that, his question is, if they do let me go, do they owe me severance? The answer is, of course they do. Now, one of the factors here is the fact that he was recruited, he says, from another job. If you get recruited from another job, you may be owed enhanced severance if you are then let go by the new company, because that severance will have to recognize the time with the previous company. But even if we forget for a second about this and we just focus on his 3 years of employment, let's calculate how much he's owed. And to do that, let me introduce you to a tool if it's the first time you've watched our show, and that tool is pocketemploymentlawyer.ca. Again, it's pocketemploymentlawyer.ca, and that allows you to find out how much severance you're owed if you lost your job. It does other things as well, but that's one of the features. So let's go to pocketemploymentlawyer.ca. Let's plug this information in, and let's see what this person is owed in terms of severance. So we know that he's in an engineering role. He's been there for 3 years. And someone in his situation, I said, let's assume he's 62 years old. Someone in his situation would be owed about 6 months' pay, but not so fast. Because he was recruited away, he could be owed even more than that. Depending on how long he worked with the previous company, he could be owed as much as 24 months' pay. So that's the answer. Yes, you absolutely are owed severance. And if you lost your job, to calculate your entitlements instantaneously, anonymously, and completely free, just go to pocketemploymentlawyer.ca.
How long does that last? I mean, how long does he have to be at the new company before he can't go back and claim previous employment with the old company? You know what I mean?
Yeah, usually about 3 to 4 years. So in the first 3 to 4 years with a company, if you are or if you have been recruited from another company, you would be owed enhanced severance. After about 4 years or so, that factor is not really going to impact your entitlements as much.
TerminationQuestions.com. That is another resource for you to ask your questions anytime. Either Lior or a member of the team will answer them. We'll get to the first one for the show today, Lior. That comes from Terry. Terry says, I was let go from a federally regulated company that has been suffering greatly due to the impact of COVID-19. After working there for 8 years in a management position, I was only given 5 days severance pay. Is that all I'm really owed?
So there's two things I want to say here right off the bat. Number one is the fact that the company may have been impacted by COVID-19, and because of that they had to let someone go, does not deprive you of your severance, not even close, okay? Even if a company is struggling financially, if they let you go, they have to pay you the severance entitlements that you are owed. And in fact, they could owe you even more severance than usual because it's a bad economy, because it's going to take you longer to find another job. You may be owed actually even more severance than usual. That's issue number one. So issue number two is this: federally regulated employers. So some employers are regulated federally, banks, telecommunications, railways. Even in those situations, the amount of severance is the same. So a provincially regulated employer or federally regulated employer, it's the same amount of severance. So it's not a question of, oh, I'm federally regulated, so I get less. No, because remember, the factors are your age, your position, and the length of your employment. Not whether you work for a federally regulated or provincially regulated. Now, this person, after 8 years, was given 5 days severance. 5 days. John is over there chuckling because he knows that that's completely inappropriate, not even close. Depending on his age and specific role, he could be anywhere from 8 to 12 months' pay. That's how much severance he's owed. So no, remember, federally regulated or provincially regulated, you absolutely get your full severance.
When do those two terms come into play, federally or provincially? Why does it matter ever?
So with respect to severance, it really doesn't matter. Your minimum entitlements may be different, but it doesn't matter. Your full entitlements are the same, what we call your common law entitlements. Now, federally regulated employees actually have additional rights. They may have a right to get their job back, believe it or not. But when it comes to severance, yes, it's the same as provincially regulated employees.
We'll take a short break, but coming up, though, temporary layoffs, what you need to know. So stick around for that. In the meantime, reaching out, 1-855-821-5900, help@employmentlawyer.ca. Lots more of the Employment Law Show is on the way. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Employment Law Show. John Scholes, Lior Samfiru, reaching out, help@employmentlawyer.ca. You can also go to pocketemploymentlawyer.ca. That is a very robust website. You can learn all kinds of stuff about employment law. There's even a section on disability law because they cross over quite often. It's free, it's anonymous, but if you want to reach out to Lior and his team, there's a contact button at the top right. Okay, temporary layoffs during COVID-19. Let's get into this. Most basic question is always the first one. What is a temporary layoff?
John, this term, temporary layoff, has literally been on the tip of everyone's tongue for the past number of months with COVID-19. Millions of people across the country have been laid off temporarily. So it's so important that we talk about this, dedicate some time to this, because it may not be what you think, and you may have rights that you don't realize that you do. But to start it off, as John asked, what is a temporary layoff? Well, a temporary layoff, the idea at least behind it, is a situation where your employment is not being terminated. You're just, as John likes to say, you're being put on ice for a little while the company figures out what it's able to do. So your employment is suspended for a period of time with the thought and the hope to perhaps bring you back when times are better. So that's different than a permanent layoff when everyone knows and agrees you're not coming back to work. Temporary layoff, by definition, is only intended to last for a specific period of time, after which you would be coming back to work.
Well, you mentioned a period of time. Is there a time limit when it comes to COVID-19 and temporary layoffs?
Now, usually there'll be a very simple answer to that, but over the past number of months, every provincial government across the country has changed the rules with temporary layoffs. In some situations, it's 8 weeks, and sometimes it's 6 months. So depending on the province that you're working, it may be a different period of time, and it could be changing as we go. In Ontario, for example, recently, the government announced that there's no temporary layoff. They only really start in September if you're not back at work. So a temporary layoff, depending on where you are, is going to have an end date to it. Easiest to do is go online, figure out in your province where you are what the government has announced, what they've said a temporary layoff has to be and how long it can last. It does change based on province.
Again, reaching out to anytime, 1-855-821-5900. It is help@employmentlawyer.ca. We're talking about temporary layoffs. What if I don't want it? Can I refuse it? I don't want to go on a temporary layoff.
This is the key to this segment. We're talking about temporary layoffs and your rights and what you can do about it. So this is important right now, what we're talking about. Here's what I need you to understand. A temporary layoff, even COVID-19 related temporary layoff, is actually not legal. Despite what I said, despite what the governments have said, all the governments have done is it allowed the government, it allowed employers to do it in specific situations, but for most people, it's not legal. Meaning, if you've been put on a temporary layoff, you have a choice. The choice is you can accept it and wait at home and see what happens. And depending on where you are, you could be waiting for months and months and months. In Ontario, you could be waiting until the spring of 2021. So that's option number one. Option number two is you can treat that layoff as a termination. You can treat that layoff as the end of your employment and get severance. That means instead of seeing what your employer is going to do, you can make that decision. I've decided, employer, that I'm not going to be coming back. I've decided that by putting me on a temporary layoff, you've essentially terminated my employment, so pay me severance. And people ask me, well, how come that is? How come? Why is that a temporary layoff or termination? Well, here's how I always like to answer, and you've heard me say this before, John. If I told you that your employer reduced your pay by 50%, you think, oh my God, clearly that's illegal. They can't reduce my pay by 50%. And you'd be absolutely right. They cannot reduce your pay by 50%. Illegal. It's a constructive dismissal. But what is a temporary layoff? A temporary layoff is a situation where your pay has been reduced by 100%, zero. So if a 50% reduction is a constructive dismissal is illegal, then certainly a 100% reduction is illegal as well. So if you've been laid off temporarily, you can treat that as a constructive dismissal. You can treat that as a termination and get your severance.
So I've been off for a while, and it's going. I still haven't called back yet. I'm waiting by the phone. What happens if I never get called back?
Well, first thing you have to decide is, do you want to go back? If your goal is to go back to work, follow up with your employer, see what their plans are. Obviously, at some point, your employer is going to have to make a decision. Do you come back to work, or do you have your employment terminated? If your employer does not call you back, yes, they have to pay you severance. They have to pay you your full severance based on your age, your position, and the length of your employment. So that's if you're inclined to go back. But as I said before, you don't have to wait if you don't want to. You can choose to treat that layoff as a termination and get your severance now. If that's what you want to do, if you said, no, enough is enough, I'm not going to wait at home, I need to do something else with my life now and move on, let's talk. Give me a call so we can connect and I can help you get the severance that you're owed.
You know, we're finding this in phone calls as well and emails. I know you get temporary layoffs during COVID-19 times. A lot of people are getting called back, but they're getting called back to maybe a lesser position, different position, few hours, less pay. What gives with that?
I've seen this often. I've seen this so many times over the last few months where some people are being called back from a temporary layoff, but at a different position. Oftentimes it's less hours or less pay, or maybe different hours. Instead of working during the day, you'll work in the evenings or the weekends. So remember the rule. And the rule is your employer does not have a right to change the terms of your employment in a significant way. If they do, you have that right to treat it as a termination. So if your employer says to you, no, I want you to come back, but I want you to come back part-time instead of full-time, you do not have to accept it. If you don't accept it, you cannot be punished. If your employment ends, you will be owed severance. Your employer cannot change terms of employment, even if it's because of COVID-19. Now, the risk here is this. If you decide to accept the pay reduction, I know my employer is struggling, so I'm going to accept the pay reduction. Okay, that is actually quite admirable. But the concern here is this. Number one is by accepting that pay reduction, as an example, that may be your new pay forever. Unless there's a written agreement with the company that they only reduce your pay temporarily, now that could be a pay reduction that's permanent, but it gets worse. The second problem is by accepting that pay reduction, you've given the company the right to do it again in the future. So the next time that they reduce your pay, you won't be able to do anything about it. So you may find yourself making almost nothing because you let that first pay reduction happen. That's why it is important to understand that if you are being put in a situation where the terms of your employment are changed, you may want to treat that as a constructive dismissal. You may want to move on with your full severance. And if that's what you want to do, reach out to me.
Would the same thing apply for those people that are going back and the employer says, I'm not going to touch your pay, I'm giving you the same amount of money, but I'm going to knock you down a couple positions as far as what you do?
Absolutely. Yeah. A demotion, even if it's with the same pay, is not something an employer is allowed to do. If it's a less prestigious responsibility, if you, for example, were a manager, now you're not a manager, that is an issue. Your job has changed. That could even hurt your future career prospects. So you can treat a demotion as a constructive dismissal, even if the pay stays the same. Again, it's not a thing your employer is allowed to do.
Again, employmentlawyer.ca is the website. You can find a resource for our radio show, a station near you that catches the show and carries it every week. We'll get to our second call from our radio show right now.
I'm currently on maternity leave, and I'm supposed to be going back to very soon. Sent an email to my employer confirming that, saying, hi, I'm just confirming that I'll be returning on such and such a date. Mm-hmm. And they sent me an email saying basically, sorry, but we're letting you go. Nothing about severance. They said that they're going to pay me vacation. They're saying they're letting me go due to lack of work.
Well, there's a lot of things here we have to unpack. And when it comes to maternity leave, parental leave, whether you're a mother or a father, your employer has a very strict obligation to take you back. They have to make efforts to take you back to the exact same role, or if that role is not available, to a very similar role. There's only a very small number of situations where the employer cannot or does not have to bring you back, and it comes down to there isn't a job. If legitimately there isn't a job for you, not because they gave it to someone else, because maybe they closed down the department. If there isn't a job, then yes, they can terminate at that point, but of course they have to pay severance. If your employer doesn't bring you back when they should be, that's a violation of the Human Rights Code, that's a violation of the Employment Standards Act. In other words, it's completely and utterly illegal. So right off the bat, I would be very concerned, why isn't this employer bringing her back? And John, I've said this before, sometimes employers are using the idea of COVID-19 as an excuse to try to justify things that they otherwise cannot do. And that is a concern in this situation. But of course she's owed severance no matter what. The employer can't say, because of financial reasons, we're not paying severance. Severance has to be paid. Just like an employer can't say, we're not paying minimum wage. Well, you have to. You have no choice. It's not an option. It's not a nice to have. It's the law. And if you don't get severance, you've been wrongfully dismissed. You really want to reach out to me in that situation.
You know, some things haven't changed during COVID-19. That is, don't mess with mama. It's a hashtag, it's a T-shirt, it's a coffee mug, I swear.
Even more than ever now. Yeah. Absolutely. Do not mess with mama.
That's it. Being recruited, or at least getting severance after being recruited, we will tackle that after a short break. In the meantime, reaching out, 1-855-821-5900. And the email is help@employmentlawyer.ca. It's the Employment Law Show. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. Let's keep right at it. Last few minutes of the show here, Lior. Again, you want to go to employmentlawyer.ca to catch our radio show. It's been going on for years and years. We get a ton of phone calls every week, and we cherry pick the good ones, or the ones that are interesting. Anyway, we play them back here. I think this is phone call number 3 for today, Lior. Here it is.
I was wrongfully dismissed. Well, that's my claim. I mean, the employer in my letter said that they dismissed me with cause, right? You could say it's a form of some kind of misconduct based on what a conversation that was misconstrued between me and another employee, or they took the measure of letting me go, right? Like, what would I be entitled to if it was even like severance? I've been like a 15-year employee, make like $52,000 a year. I'm 46.
You know, I've said this a number of times already on the show, but there's quite a few things to unpack here. And the main thing, and the thing I need to bring up to everyone's attention, is just how difficult it is to terminate someone's employment for cause. So this person in the call says, well, I had some sort of a disagreement, they let me go for cause. Well, no, not even close. It's extremely difficult to terminate for cause. You would have had to do something terrible in order for the employer to legally be able to let you go for cause. You know, maybe you hit someone, you know, maybe you threatened someone. Maybe then we're starting to talk about cause. But having a disagreement, absolutely, certainly as an isolated incident, will never be cause. So yes, he likely has been wrongfully dismissed. And I want you to remember that you may have done something wrong, but that does not give your employer the right to let you go for cause, not at all. So the next question is, well, okay, we know it's not cause. We know he's owed severance. How much severance does he get? So I told you before about the pocketemploymentlawyer.ca. By the way, one of the things the pocketemploymentlawyer.ca does is allows you to figure out if there was just cause to let you go. So you can always go there if you're not sure if what you did is bad enough to be cause. Check it out. The other thing, as I mentioned, is it calculates your severance. So let's go to pocketemploymentlawyer.ca. Let's plug this person information into there and let's see how much he's actually owed. So let's say this person is in a sales role. We know he's been there for 15 years, that he's 46 years old, making $52,000. He wasn't given any severance because his employer said wrongly that there's cause to let him go. Well, we can see right there on the screen, based on pocketemploymentlawyer.ca, that he's owed anywhere from 14 to 16 months pay. That's somewhere between $60,000 to $69,000 that he is legally owed. Now, again, this is a common situation. I see pretty much this identical situation multiple times a day. If you've been let go with or without cause, first thing you do, grab your tablet, grab your smartphone, your desktop, and go to pocketemploymentlawyer.ca.
I want to go back to terminationquestions.com for the final question here, Lior. This one's Brett. Brett writes and says, I was pulled into a meeting and handed a termination letter that included a severance offer. At first, my boss refused to let me leave without signing it, but I was able to negotiate a 24-hour grace period. Can you review my severance package before the time limit expires?
You know, I have in the last number of years seen a few situations where the employer says, you're not leaving this room until you sign it. You understand, John, that that's actually a criminal offense. That's essentially trying to imprison someone illegally. You must sign this now or else. What the heck are you talking about? That's ridiculous. That's nonsense. And by the way, a word of advice. If your employer is telling you that you have to sign that severance offer on the spot, you don't have to. Don't sign it. But if you end up signing it because of that pressure, you can probably get out of it, because telling you to sign it on the spot, it's nonsense. It's illegal. Now, this person didn't sign it. They got a 24-hour grace period. And I get often calls saying, my God, Lior, my severance package expires today or tomorrow. I need to meet with you immediately to review the severance offer. That's great. I'm happy to meet. I'm happy to talk. But don't stress out over it. Your legal rights don't expire today or tomorrow or even next month. In fact, your legal rights don't expire for 2 years, 2 whole years. That deadline, that date on the severance letter is a pressure tactic. That's all it is. It's a pressure tactic designed to make you think that you will lose something, that you have to sign or you will not get paid. It's not that way. The law decides what you're owed, not your employer, not me, by the way. The law takes care of that. So if you're owed 20 months severance, you have to get 20 months severance, whether you sign this today, tomorrow, or a year from now. So do not stress out about these dates. Let's have a chat. Let's make sure you get what you're owed. That deadline is meaningless. Your rights don't expire like that. And I'll help you get everything that you're owed. Absolutely.
And I mean, even most employers that even put a deadline, because there's always a deadline on a severance offer, they know that you're probably going to go and call someone like yourself and realize this isn't adequate by any stretch and come back with a better offer. I mean, they know this happens, right?
Well, here's the thing, John. I've said that 90% of people get inadequate severance. That's a mathematical fact. I've been doing this for a long time. But there's another mathematical fact, and that is 90% of people that are let go are actually going to accept it because they don't know any better. They get misinformation, they think it's adequate, not realizing that they're owed much more. So for an employer to offer bad packages is actually something that they often get away with. If they're going to let go 10 people, offer all of them bad packages, 8 or 9 out of those 10 will accept it. Well, if you're watching the show, you're not going to be one of those 8 or 9 people. You know better. You know what to do. You call me. You go to pocketemploymentlawyer.ca. You call another employment lawyer if you don't want to talk to me. But you get that advice so that you don't accept inadequate severance.
Good way to end it right there. Again, pocketemploymentlawyer.ca. That is that website. We keep talking about it. Free and absolutely anonymous, so get on it. 1-855-821-5900. help@employmentlawyer.ca is the email address we use. And if you go to employmentlawyer.ca, you can catch past shows and radio shows as well. So we'll see you next time in the Employment Law Show. Appreciate you sticking with us.